Defamation in public relations. What's it all about? To help understand defamation in public relations, we will take a look at two court cases that help define the modern defamation laws presented today. Part 1 is New York Times v. Sullivan, and Part 2 is Gertz v. Robert Welch, Inc. Part 1, New York Times v. Sullivan. The First Amendment says, quote, Congress shall make no law representing an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. Unquote. The First Amendment was tried on who it protects in the case of New York Times v. Sullivan. New York Times v. Sullivan's case was about Abbi Sullivan, who sued the New York Times and 4 Alabama clergymen over an ad that was placed in the newspaper on March 29, 1960. The ad was called Heed the Rising Voices, which was about how under the U.S. Constitution everyone deserves the right to freedom. The ad describes situations that are happening for the African Americans that are unjust. The ad said, quote, they are being met by an unprecedented wave of terror by those who would deny and negate the document which the whole world looks upon as setting the pattern for modern freedom, unquote. Abbi Sullivan was the, quote, Commissioner of Public Affairs, unquote, whose responsibilities, quote, are supervision of the police department, fire department, Department of Cemetery, and Department of Scales, unquote. The ad uses the word police to describe those who hinder the freedom for the African Americans. Sullivan took offense to this, as since he was in charge of the police in Alabama. Here are the 3 areas in the ad that Sullivan had issues with, amongst others. In the ad, it said, students sang, quote, my country, 'tis of thee, unquote. They actually sang the national anthem. The students were padlocked in their cafeteria, quote, to starve into submission, unquote. In actuality, the students who couldn't eat in the cafeteria was because they didn't sign up to eat there. The third was Martin Luther King Jr. was arrested 7 times. He was only arrested 4 times. The case went to the Alabama State Court, and they ruled for Sullivan, saying that the article defamed him. The state judge said Sullivan didn't need to show liable to recover damages and won $500,000. The Alabama Supreme Court agreed. The New York Times took the case to the United States Supreme Court, and they said that there was one thing that needed to be decided. Quote, the question before us is whether this rule of liability as applied to an action brought by a public official against critics of his own official conduct abridges the freedom of speech and the press that is guaranteed by the First and 14th Amendment, unquote. The Supreme Court found that intent malice needed to be proven by Sullivan in order for damages to be awarded. The evidence did not support that, so the conviction was overturned. Sullivan was a public official, so the court decided he should understand that this type of attention comes with his post. Defamation laws are there to protect individuals and businesses from false statements about themselves. Libel is a false statement that is written or published. Slander occurs when a statement is spoken by voice on a radio or on a television, such as a newscast. Defamation has to be proven in court in order for the plaintiff to receive damages. The 3 ways defamation can be proven are, in quote, the defamation made a false and defamatory statement concerning the plaintiff. The defendant made an unprivileged publication to a third party, and the publisher acted at least negligently in publishing the communication, unquote. This case is important because it, quote, establishes the requirement of actual malice in defamation suits brought by public officials, unquote. Part 2. Gertz vs. Robert Welch, Inc. Elmer Gertz was a lawyer hired by the family of Ronald Nelson. Nelson was killed by a Chicago police officer who was convicted of second-degree murder. Nelson's family took the police officer to court in a civil litigation. 1 year after the case, a publication called American Opinion ran articles that were not true about a communist conspiracy to discredit local police and inadvertently replace them to run their own communist agenda, a national police force. Gertz's case was one of these articles that used him as a pawn to prove their case on local police. The publisher said Gertz arranged the conviction of the police officer, that he was a member of the communist gang, that he had a criminal record, and used anti-communist name-calling against him. None of these accusations were ever proven by the publisher before the article was published. They said that they trusted their source. Gertz took Robert Welch, Inc., who owned American Opinion, to court for libel. The lower courts favored Gertz and awarded him punitive damages of $50,000, saying he was a public figure. The publisher asked the court for notwithstanding the verdict and was granted suit. Gertz took the case to the Supreme Court of the United States. The court found that private individuals may be awarded actual damages if they can prove malice was made intentional by the speaker. They also said state courts can set the standard for defamation to private individuals. My opinion on both of these cases gets down to proven facts. If you have a source, you should always be able to prove their authenticity in what they say and do. If you are taken to court, you can prove yourself true and reliable. I live in the state of New Mexico, and they state that, quote, a plaintiff must prove the defendant communicated a false statement of fact to a third party, unquote.